think it's 2:30, so let's get started. Hello everyone, my name is Howard Williams. I'm the Continuing Education Coordinator here at Alpha. Hopefully everyone can see and hear me as well. If you can't, just please check the volume on your computer. Here at the bottom screen, bottom right of the screen, if you want to send me a question, you can just type your question in here and I will see it, and I'll try my best to answer your question. Today I'm going to talk about Chapter 7. The importance of Chapter 7 is about 25% of the questions from your final on the national portion comes from Chapter 7. So it's probably the biggest chapter you have. It is actually. We have some of our classroom people who got still here, but some of you are online people as well, so you might be hearing this for the first time. We are recording this, so once we finish recording it and Cliff does what he has to do with it, then we'll be sending it to, as we're sending it to you now, this link you'll be able to see at your leisure anytime you want. So let's try to get started here. Agency is basically who you represent. You do need to know the textbook definition of it. The agency is when the principal delegates another person the right to act on the principal's behalf. Now, it's important that you understand that when we're talking about agency in itself, that a principal is your client. Now, in every real estate transaction, there are three parties. You have in every real estate transaction, you have the principal, the agent, and third parties. Third parties are customers. So, in far as who we represent, you need to understand and keep in mind that, like the far left column here, keep in mind that your principal is your client. Those two terms are interchangeable, and your principal is always your client. Your client is always your principal. And the important thing is to try to understand the difference between a client and a principal. A client, there is no difference between a client and a principal, but you want to understand the difference between a client and a customer. People are either one or two things to you. They are a client or they are a customer, either or. So the difficulty in your relationship or your agency relationship is determining which one they are to you. If they are your client, you work for that person. You give that person advice. You look out for them. You're on their side. You always look out for them. In our agency relationship, you as a licensee have similar duties as an attorney has to their clients, where an attorney looks out for their client's interests, does everything for their client's interests. So do we. Is very similar to that. Your principal is your client. Now, I said in every relationship, in every transaction, you have the principal, agent, and third parties. The agent in a transaction is the firm. So the principal is the client, the agent is the firm, and third parties are customers. Customers are people that you work with in the transaction. They're all the people that are not the client. The bank is a third party, is a customer. The settlement agent, the roofer, the plumber, anybody that does any work on the house, the loan officer, everybody else in the transaction is called a customer. Now, we don't work for customers, we work with customers. We don't represent customers. What we do is we provide them information, is what we do. We don't tell them anything that can hurt our clients' interests. You see on the chart here or on the screen where the principal can be a buyer and a seller, a buyer or a seller, and the reason that is, it depends on who you represent in that transaction. Sometimes you represent the seller in the transaction, and sometimes you represent the buyer. So, of course, if you represent the buyer as a client, then the seller is your customer, and vice versa. If the seller is your client, then the buyer is a customer. So when we look at this basic concept, you just have to figure out who everyone is to you. Because once you figure that out, then you're good. Now, you may ask yourself, how do I determine when a person starts from a customer and becomes a client. Let's talk about that a second. In real estate is one of the few businesses that it is not good to be a customer, or you don't have your greatest benefits by being a customer. A client has all the benefits. Customers don't have the benefits. Clients do. Because we advise clients, we tell them what to do, we advise them. Customers, we only tell them information. We only tell them what they can do. We don't tell them what to do or advise them what to do. If a customer wants to do something that's not to their benefit, then we can't say anything about it. We just got to let them do it. Or if they want to do something that, and the other main thing, if you do something like an open house and a person comes into your open house and you're representing the seller, anything that customer says to you, you must tell your seller. Anything they say, you have to tell your seller. You look out for your client's interest 100% of the time, regardless of it hurts the customer or not. It may hurt that customer's interest, but you have to you represent your client. An example would be if a customer told you that they would pay $10,000 more for a house, then you need to tell your client, which is your principal, that that buyer, customer, would pay $10,000 more for my house. You need to let them know that. And consequently, if your principal, which is, let's say your seller was your client, your principal, and your sellers told you that they would sell their house for $10,000 less, you would not tell customers that, because that could hurt your seller's position. So you wouldn't tell your seller that. So the point with that, of all that is from a transaction is from the day a person, i.e., once the day a person becomes your client to the day y'all leave the closing table, anything that you know that will affect that client's decision or could affect their decision, then you must tell your client. Anything that would affect your client's decision, no matter what phase of the transaction you're at, you must tell your client. Everything. You must tell them it doesn't matter. Whether it's good, bad, even if you have a ratified contract. Your contract is ratified. You're 2 days from closing and something like another offer come in. You got to tell your client, I got another offer that came in. Or even good news or even bad news. Or if your client is selling their house and then a couple of days before closing, you find out that the value of their property is about to double because they're going to build something in the community. You still have to tell your client that. It can't stop them from closing, but you have to tell them anyway. So whether the news is good or bad, if it affects the transaction or could it affect someone's decision, then you have to disclose it. So you would, if the, i.e. if you're working with the customer and you knew that your customer, you have a ratified contract with the customer, and you represent the seller as a client, and you know for some reason your client's property may lose value in the future, you can't tell that customer that, because that would hurt your client, your seller client's interest, and so you wouldn't tell them that. Okay. When we talk about giving them stuff like information, the customer, I mean, like you can tell the customer, like information like this is a 3-bedroom, 2.5 bath. The seller wants $300,000 for it. That's information. What I mean by advice, if the buyer asks you, if the buyer was a customer and the buyer asks you, do you think the seller will take a lower price? Then they're asking for your advice. Or if they say to you, do you think the seller will pay my closing costs? Now they're asking for your advice. And before you answer that question, okay. All right. So somebody's, oh, that's what I thought. Somebody principal room. We have, you're freezing up. I'm freezing up. Cliff, are you frozen? I'm frozen. Oh, Cliff. All right. Whoa. All right, with Cliff is typing. Okay, Cliff said we're good now. We're good now, I guess. Okay, all right. Technology, huh? All right, Cliff is handling everything, so Cliff is online with us. So Cliff kind of hang with us on this to in case we have some technical issues. So hang with us. Alright, so our principal is our client, and as our client, we love our principals. We do everything to help them, everything to assist them. We look out for them. We take care of them just like they're our little children, our little puppies. We take care of them. Our job, we put their interests all above ours. It's never about us. It's always about them. Never about us. We have to look out for them. If they're a client, not a customer though, but they're a client. Customers, we owe honesty and fair dealing to customers. Only honesty and fair dealing. We don't have to be, we don't look out for their interests. Your text talks a little bit about fiduciary obligations, and what we mean by fiduciary obligations is ours as a licensee to our clients, the relationship of trust and honesty that we have to our clients. Personal performance, i.e. if you have a listing contract, whatever the listing contract says, you must do. If you have a buyer broker agreement, whatever that says, you must do. We must perform the job that we were hired to do, and we look out for their interests. We do whatever our client says as long as it's legal and ethical. We must do what they say. A lot of times we may not even agree with what they say, but example, if you know the sales price in the neighborhood is $300,000 and every house is sold for $300,000, and your seller wants to sell his for $350,000, then you have to put it on the market for $350,000, even though you may know it may not sell, or may not sell at all. You have to obey their directions. If you don't, then that's reason for you to get in trouble, and it'll be an issue with your license. We are 100% loyal. We don't put any other client or any other person above our client. We always just look out for their interests only, even if it hurts us. And what I mean by that, even if it hurts us, let's say the seller wants to take a lower price that would make your commission lower, then you have to go with that. You have to do it. It's not about you. So if the seller wanted to give the house away, then your commission is based upon that, whatever they want to do. During the transactions, you may be entrusted with clients' funds. And if you're entrusted with those funds, you must take care of those funds that belong to your client. You can't, they give you some money, a check, a money order, something like that. And we're going to talk about where it goes on the next screen, but you must account for all the money entrusted in you. You must be account for it 100% of the time. During the transaction, there's a lot of paperwork. It's not just the paperwork the first day we meet. It's even paperwork after you meet, do the contract. As far as notice, anytime any paperwork needs to be done or any kind of changes need to be done, you must make sure your client is aware of the changes. Like I said, whether the change is good or bad or whatever, you need to let your client know what's going on through the entire process. And I'm emphasizing that through the entire process from the beginning to the end. Really things like due or reasonable care is like if you go to their house and you go in the house, you show the property, make sure you lock the door when you leave. If you turn on lights, make sure you turn the lights off when you leave. Don't let the cat out. Put the dog in the garage before you show the property. Stuff like that. If your client is gone for the weekend, it's okay to have the grass cut or something like that. Or if the water line breaks, it's okay to go turn the water off. just reasonable care of things, and it's okay doing those things for the client to reimburse you as well for that. This fiduciary obligation is, we have the acronym. Your textbook says the acronym for Poland for it, with the first letter of each term. If that's an easy way for you to remember it. Any questions on, again, anytime you have any questions, you can type it at the bottom. I guess we're okay with the screen because I haven't heard anything else from any of you, so I guess we're doing okay. And so let's try the next one. I was talking about the accountability issue. Now you have, and you're going to talk about this a lot in Virginia law, the firm, the monies that customers and clients give you or entrust to you must go into an account called the escrow account. Now, an escrow account, you need to remember this because this is going to be on your test. An escrow account is where clients and customers' monies go. All their monies go in this one escrow account. You don't need an escrow account for every client, just one big account, and that's where all clients and customers' monies go. When a real estate business has several banking accounts, but they're going to have at least 2 accounts, and they must have at least have one account that's labeled at the bank, labeled escrow account. Now, if we were opening our own business, then we would have to open the bank. We would have to have at least 2 accounts. We would have an operating account, and then we would have an escrow account. Now, this operating account is where the firm or the company pays its bills, where they pay their rent, where they pay your agent commission checks, or just expenses for running the business come out this operating account. Again, in the escrow account is where all the clients and customers' monies go. Now, if we just open up our firm today and we don't have any clients, then of course we wouldn't have any money in the escrow account. So let's just say hypothetically we are opening up today and we don't have clients' monies to do the escrow account, then we can take money out of our operating account to open the escrow account. Again, you can take money out the operating account to open the escrow account. Okay, so now we got the escrow account open with some funds we took from operating, and then next week one of you get a client and you have a ratified contract, and the client gives you earnest money deposit. Now we know that earnest money should go in the escrow account. Okay, so you go to put the money in the escrow account, and the money that's in there already is from the operating account. That operating account money must now come out. You can't mix the two. That's what they call commingling. Commingling is mixing the operating funds or the firm's funds with clients' monies, and you can't do that. That's illegal. That'll get the firm shut down very quickly. So our rule is this: the only time operating funds or firm's personal funds can go into the escrow account is to open it. And once we get clients and customers' monies, then that firm's personal funds must come out of the escrow account, and never the two shall meet again. Now, when they're mixed together, that's called commingling. And you need to remember that, because you're going to talk about commingling in the national portion, but also you're going to talk about this commingling in the state portion as well. So commingling is illegal. It is a violation. I would tell you right now that, and we'll talk about in Virginia law, at any time it wants, the real estate board can come to your office during normal business hours and say, let's open up the records, let's see what you got. And if your contracts say that you got $500,000 in the escrow account, when they go to the bank, it better be $500,000 in the escrow account. They must match your books, or then the real estate board would take over and try to find out what happened to the money. I was asked during class, what if it was the account got any interest, what would happen during the interest? Well, if it went to an interest-bearing account, then the firm would get the interest. Most of our contracts state that the earnest money deposit, if it goes into an interest-bearing account, then the interest belongs to the firm. So in essence, if it was, $5,000 of earned interest in the escrow account, then the firm could take that $5,000 out. Again, only time you can put operating funds in the escrow account is to open it. Once you put client's funds, take that money out, and never the two shall meet again. And when they meet, it's called commingling. That's illegal. It'll get the firm shut down very quickly if that becomes a issue. So let's see. That money can only come out three ways as well. The money in the escrow account can only come out the escrow account three ways, and the three ways are if the transaction closes. So the transaction closes, so everybody happy, everybody gets paid. That money can come out then. If the transaction doesn't close, if all parties agree to take it out in writing now, then it can come out. But if the transaction doesn't close, and the parties can't agree in writing as to the disposition of the money, then there has to be a court decide what happens to the money. At that point, a court will decide then what happens to the money. And that's the only three ways it comes out. And you will see this talked about further in the chapters as well. Your three ways. The transaction closes, where the money comes out of the escrow account, the transaction closes, we got a written agreement, or the court would decide, the judge would decide who gets to earn this money. Written agreement could be the contract states what happens if it doesn't close. The buyer and the seller could do a release agreement, and that would say where the money would go. But either or, these three things are the only three ways that money can come out the escrow account. Another little point, like I said, I'm not going over every item in the chapter. I just want to hit a couple of high points that students tend to have problems with. Your text talks about antitrust laws. And I want you to remember everything on this particular screen, that I want you to know that antitrust laws protect free enterprise system. That's what they do, to protect the free enterprise system. And the two greatest violations of antitrust laws in real estate is price fixing, is firms getting together. Let's say two firms get together and set the commission rate. Like the people on the screen, the people on the screen right there, they sit at the table and saying, all right, all of us going to set the commission at 8%. So all of us be the same. So no matter what place somebody go, the commission will be 8%. So you can't do that. That's illegal. The second biggest violation is the allocation of customers or markets. And what I mean by the allocation of customers or markets, I mean is someone to say, you sell all the houses on the peninsula, and I'll sell all the houses on the south side. Where they just break it down, or I'll take people who buy under 500,000, and you take people who buy houses over 500,000. So you can't do that. So because they consider that manipulating the market and messing with free enterprise system. So no price fixing or allocation of customers or markets can two firms get together and try to set that price. The market itself should set those prices. The second biggest part of your agency class, or your chapter 7, was fair housing. Now, I do want to say that I do have, I think, a couple of typos on here, but this one is not. Since 1866, not 1966, 1866, from the Civil Rights Act of 1866, it has been illegal to discriminate in housing based upon race. As part of the 14th Amendment, which is talked about in your textbook, and as well as for your online people on your material as well. But I do want you to remember that date, and that it is legal to discriminate in housing based upon race. So the Federal Fair Housing Act, so in 1866 they had race, and then 1968 they added protected class. Now so we're talking about protected classes, and race is the first protected class. And then in 1968 they added color, religion, sex, and national origin in 1968. One thing I want you to remember about protected classes, they always add protected classes and never take away. So those that are there now will always be there, and they only add, which we're going to talk about two others they add, but I want you to remember that they only add to the protected classes, the number of them. They should be adding another one pretty soon. Gender bias, sex bias, something like that. Anyway, 1968 they added color, religion, sex, and national origin to race in 1968. Also in your book, it talked about 1968. It talked about the exemptions, how people can get around the 1968 law. And one of the ways, if you sell your own house, and I want you also to remember that residential dwellings are 1 to 4 units. Anything over 4 units is commercial, but residential is 1 to 4. So if you have 1 to 4 units and you live in one of them, or you have 1 unit, then you can discriminate as far as who you sell to, as these protected classes go. Also things like church organizations or religious organizations who only have housing for their members, but membership into it is not based upon race. So as long as, again, the membership is not based upon race. And also the other big point your text talked about, that these are private religious or clubs don't operate commercially as well. They have to be total for their members and not open to the general public commercially. If they are open commercially, then they can't violate this 1968 law. So in 1988, they added handicap and familiar status. Handicap is families, and familiar status, handicap, familiar status is families. Those are children under 18 years of age, and familiar status, they also include pregnant women, and they also include those who adopt children as familiar status. The main thing I think about when I talk about handicap is to make sure that, of course, you cannot discriminate against a handicapped person. You'll talk about it some more in Virginia law, but you have to make a handicapped person make reasonable modifications. They have to be able to make reasonable modifications, and to make sure you remember, remember your definition of what handicap is. But they can't hide their handicap status. You have to make reasonable modifications at their expense. You have to decide up front what condition you want them to return the structure in after their stay is over. Just as things like if they have a CNI dog, and you have a no pet policy, you have to allow the pet in there. You cannot charge them higher rent because of the pet, but you can charge them a pet deposit. Again, you cannot charge them higher rent because they have a pet, but you can charge them a pet deposit in case any damage the pet does. You can do that for them. Again, 1988 is when they added handicap status, handicap familiar status to the protected classes. And currently that's all the protected classes that we have. Your book also started talking about things like blockbusting, staring, and redlining. So let's go over them for a second. Blockbusting is panic selling. It's like you as a licensee, you run into a neighborhood and tell everybody in the neighborhood that they need to move because a certain race is coming to the neighborhood, or a certain type of people are coming to the neighborhood, so they need to move. It's going into the neighborhood, just causing panic. and trying to get people to sell their house before, i.e., the green people get here or something like that. So blockbusting is panic selling. You need to remember that. Of course, again, we're talking about fair housing violations, and it is one. The second one you see is called steering. Steering is when a licensee will take someone to a neighborhood that the licensee wants them to go to, rather than where they're saying they want to go to. An example of that is, I said I want to look at houses in Chesapeake, and you say, Howard, I don't want you to look at houses in this part of Chesapeake. I want you to look at houses in that part of Chesapeake. So you're steering me. You're steering me where you want me to go versus where I, as the client, want to go. And that's what steering is. So we're talking about blockbusting, steering, and redlining. And I'm saying that you need to make sure that you know the difference between the three, because you'll see them again on your test. Redlining is mainly through lenders, where they charge a person a higher interest rate just because they want to live in a certain neighborhood. Has nothing to do with their credit worthiness. All it has to do with is just because you want to live here, we're going to charge you a higher interest rate. Those neighborhoods do tend to be older neighborhoods or neighborhoods with higher concentration of minorities. For some reason, it seems like your tests love bundling those three together. It loves putting like answer A, blockbusting, answer B, steering, and answer C, redlining. They like putting all of them together on a test. So be mindful of the differences between the three. Now, when I was talking about the exemptions to the 1968 law, where it did say that you could discriminate on race, but let's say if a person was discriminated based upon their race, and you would say, according to the 1968 law, I don't have to rent to you because of your race. Well, you are absolutely correct. Because of the 1968 law, you do not. But what the person would probably take you to court for was the 1866 law, which states that you cannot discriminate based upon race. 68 added an exemption, but a person would prosecute you, or they would prosecute you under the 1866 law. So under no circumstances can race, you discriminate based upon race. You do have loopholes with the others, but not race. As far as those 1968 exemptions, I don't know if I told you or not, but you as a licensee can never be part of any kind of fair housing violations. You can't be a part of it in any shape, form, or fashion. You can't give nobody advice about it. You can't talk to them about it. If somebody talks to you about violating fair housing laws, then the first thing out of your mouth is, I need to get away from you. Let's run from them. And 1-800, go tell your broker, hey, I need to let you know that so-and-so asked me to do this, so-and-so asked me to do this. Unfortunately, though, what has happened is that most of the time, the people who ask you to help violate fair housing laws are people you know. So that can make it a little difficult. But believe you me, you would lose your license. I'm sure you don't want to go through all this to turn around and lose your license. Because if your firm knows about it, anybody find out about it, they have to turn you in with another agent. You can be sure another agent is not going to let you violate fair housing that hurts their client. It's not going to happen. So now, let us be clear on this agency thing, that as we talk about agency, that you represent your clients to the fullest from start to finish, beginning to end. No matter what phase you are in the transaction, you must always look out for your client's interests. The last part of the last page talks about a community is intended for older persons, and I generally, think of them as the two other ones at the bottom, two other ones up there. The 62-year-old rule or 100% rule, 100% rule says that everybody who lives there must be at least 62. No exemptions. Everybody there must be at least 62 years of age. Now, the second one type of homes for older persons says that in 80, I have a typo up there where it says 85%, but it's actually 80%, where it says one person has to be at least 55 in each unit in 80%, not 85%, in 80% of the units must have at least one person 55. So a person 55 can live there with their children, right? As long as somebody in the structure is 55. Now the other 20% can be anybody. Anybody authorized to live there can be in that other 20%. You just can't pick it like an old house and call it a senior community. Those communities must have facilities and services that support the seniors and i.e. Their lifestyle. So, does anybody have any questions? Anybody got any questions or anything? Make sure as I'm waiting to see if anybody's going to type anything, just make sure that you go through chapter 7 and look at it real good. Those of you that were here today, or those of you, Jim will be going over this chapter again tonight. So if you wanted to come back tonight to go over it again, of course you have that opportunity to do so as well. It looks like we're going to, again, Cliff is recording this. So once he cleans it up or whatever he has to do with it, the link will be available to you, even those of you that are viewing it live now. The link, it'll be your same link, but when Cliff clean it up, you will be able to click it and see it again, and of course you can back it up, rewind it, or anything like that to make it easy for you. The next one, I'm not sure how I'm going to do that. I see somebody in the principal rooms is typing it. Y'all okay? Y'all okay in there? Okay. On the first exemption of the 1968 FHA, what does it mean when they say if the owner is not living in the dwelling at the time? Well, what they mean that says FHA, what does it mean FHA when they say if the owner is not living in there? Let me see if I see the other part. Is that the owner wasn't occupant? Oh, it says that the owner is not living in the dwelling at the time of the transaction, meaning the sale of the house, meaning at the sale of the house itself, or they had been rented to someone else before. That the owner was not living in it at the same time, or was not the most recent occupant. But they're saying that provided they can only do like one sale in within the 2-year period. So they're just putting limitations on it. I think the main part that I want you to understand about that is that that exemption, that part of the exemption, I don't think is a big deal for you. What I think is the big deal for you is when we talk about residential dwellings being 1 to 4 units. I think it's a big deal, and that the seller or owner can't use you, i.e. as a licensee, as a salesperson, in any part of any discrimination, nor can they advertise. I know that our test won't go into detail about if the owner is not living in the dwelling at the time of the transaction or most recent. It probably won't go that, I'm not aware of it going that deep, but basically, if you own, that you as the owner have the right to avoid the 1968 law. Keep in mind, though, even you're born in 1968 law, remember the 1866 law still applies to you. And the other problem with if you violate fair housing laws is that not only can the state government get you, but I mean the federal government can get you too. So you can get sued by everybody, not only individuals, but the federal government and the state government could sue you as well. The Department of Justice could come looking for you. That's not good. Also, the fine for the violating antitrust laws can send you to prison for 3 years. $1 million fine could be for corporations, and $100,000 fines for non-corporations. So fair housing violations is not a good, violating fair housing is not a good idea. Anybody else got any questions? If you have any questions, you know that on our website, alphacollegeofrealestate.com, on the home page, there's a link to the left that says RE Counselor, and that's Real Estate Counselor. So that's me. If you click on that, it'll email me directly, and I'll be more than happy to answer any question that you have. Or you can call me here at the school, and of course I'll take your call provided I'm not in class. But the number to here to the school is, of course, area code 757-427-1740. 757-427-1740. Other than that, if like I said, I promise you I wouldn't keep you long. I think I hit the real hot points that I wanted to for this chapter. Other than that, everyone have a good weekend, and I'll see you students on Monday. Thanks, everybody. Bye-bye.